governments have sought to expand the area of public use to try and get into the areas of development or redevelopment. And this has probably created the most contentious area in the eminent domain law with regards to the whole public use issue. A lot of this focuses around the concept of blight. And you might say, well, what is blight? When the concept of blight was first addressed and basically extended to allow for the basis of exercising the power of eminent domain back in the basically in the 1950s, blight was basically viewed as a real deteriorating neighborhood, and municipalities looked at this problem and said, how can we correct this? And they felt the only way to correct that was they would have to acquire, through eminent domain, if necessary, the land within the blighted area so that the blight could be removed and the land then resold either to a developer so that some new economic growth could be built on the land. Over the years, this concept of blight has kind of been pushed, I guess, to the limit by condemning authorities, because what they were trying to do is look for reasons to try and do economic redevelopment. So as a result, they used blight and labeled properties as being blight, which a lot of people felt under what we would probably all agree is a classic definition of blight did not really fit that classic definition. The courts historically did not maybe take as hard-nosed a stand to determine whether or not a truly objective blight standard had been satisfied. This whole concept, I guess, probably culminated in a decision a few years ago called Kelo versus City of New London, where this particular municipality, New London, Connecticut, actually went out and wanted to do redevelopment, and they didn't even rely on blight. They just basically said, we want to create a more valuable tax base, and so we are going to take property under the power of eminent domain strictly and for the sole reason of creating a more valuable tax base. And they argued, or they believed, and later argued to the court, that the creation of a more valuable tax base was in fact a sufficient public use to justify taking property away from one private property owner and giving it to another. And the case was actually appealed to the U.S. Supreme Court. There, in a very contentious 5-4 decision, it was a split decision, the Supreme Court basically came down and said they didn't necessarily agree that economic development was a proper public use, if you will, to be used anywhere. What they basically said was the federal government, through the federal Constitution, would not stand in the way of a taking for redevelopment for solely increased tax benefit purposes as a proper public use, basically saying that that issue was to be left for the states. So theoretically, each state could have a different conclusion as to whether economic development was a proper basis for exercising eminent domain under a public use standard. Well, as you can probably imagine, because of the tremendous outrage that was created throughout the country, many legislatures around the country then passed laws prohibiting this type of taking. And now the battlefront, if you will, or the battleground, the battle line, whatever term you want to use as far as blight is concerned, is whether or not the condemning authorities, the governmental units that are seeking to redevelop what they consider lower grade neighborhoods, are now classifying them as blighted and basically abusing the term blight in order to satisfy the public use criteria for the taking. The term that's often used is that the governmental authority is using blight as a pretext for the right to take property even though it may not truly be blighted in an objective term. They are calling it so that they can acquire the property and redevelop it for another, more valuable use. This is an area that is still not settled. There is a lot of litigation in this area, and I expect until truly objective blight standards are established on a state-by-state basis, this will continue to be an area that is going to see a lot of litigation in the court system.